All right, Valerie Campion, custody. Carlos Perez. Carlos Perez. Can I have the microphone, please? Thank you. Oscar Carrillo. Thank you. Robert Keonis, custody, and you said he's in the hospital?
Yes, Judge.
John Henry Moore, custody. Ricardo Cantu, custody. And when you all have them, you can just bring them out. Yes. All right, thank you. Christina Canales. All right, we will see what happens. And let me see. Vashon, did you order somebody by Zoom? All right, let's see who this is. All right, if you could unmute, please, and show your video. Ah, are you Mr. Keonis?
That's me, Judge.
All right, I'm sorry to hear that you're in the hospital. Deputy?
Yes, ma'am. Yes, ma'am.
We're just waiting for his attorney. I'll call his attorney right now to let him know his client is in the hospital and have him get here immediately, okay?
Yes, ma'am.
All right, thank you. Just
Thank
give me a moment.
Yes, ma'am.
All right, Mr. Keonis, your attorney is in the building in the 437th, but he's coming up the stairs right now.
All right, Judge. Thank
All
you.
right, thank you.
Right here.
This is for you. It's up. That's for you to wear.
Oh, really? Oh, okay. Just a second, dude.
It's for the court reporter to hear.
Okay, I never, yeah, that's interesting. I never.
And the only person who can hear it, but she hears it from specific distances. So don't take it to, certain places if you need a break.
Oh, get it, okay. Well, I just went, so it should be good. Okay.
Get some tape. People think that it's for me to hear or somebody else to hear. I'm like, no, it's Cindy. Because she wears headphones and it makes it easier for her to hear.
Yeah, I don't have any problem. I just didn't, I've never been.
And see, that is why I always tell people, you should explain. When we went to judges school, they say as little as possible. And I'm like, I want to make people know that I heard them, and I internalized what was said. I remember being a defense attorney, there was nothing, of course, there are other worse things, so I shouldn't say nothing worse than, but you would spend all night, doing your thing, and then you come in, you make your argument to the court, you're calling witnesses, you're feeling great for you and your client, and then 2 seconds later, the judge is like, denied.
Yeah, Yeah, yeah. I'm kind of glad that we went, like, I've been having like bad allergies, so I was glad that we went like one extra night of sleep and really helped me. I
Oh,
could barely talk.
Oh. Hi, Robert. So this is, well, you've met your client
Yes.
before. So he's in the hospital. I don't know what happened. If you want to zoom in, you can zoom in and I can put you all in the breakout room or if
Well,
you
I
want to
can
tell
tell
me
you
what's
that
going
the
on.
other case just got indicted. I thought it was out of the same fact pattern, but it's not.
Okay.
So if I probably need a couple weeks, I need to look at the discovery to see, because the offer's a TDC offer.
Oh, no, don't tell me the offer.
Yeah, but I just
Yeah.
need to look at it. I can't just willy-nilly make
Oh,
an
well,
offer without looking at the discovery.
I don't want you to do that.
Nothing willy-nilly.
No, we don't do that. But we are going to do some research to find out where that saying comes from.
I don't know. Probably Willy Wonka.
All right, so Mr. Kianis,
Is there a way to like mute it?
are you able to hear Mr. Kianis?
Oh, yes, ma'am.
All right, so anyway, your attorney has
I have it
just
on.
informed me
Sure.
that he received some new information. It is on a completely
Okay.
different case. So he's asking for a
You know, but
replay.
like, you know,
You understand?
I heard. Yes, ma'am.
All right.
I just didn't
So
know if-
how much
so-
time are you asking
so I
for?
have a-
Yeah, I'd say.
Yeah.
Is the discovery uploaded on?
On the new case?
Yes.
Yeah.
Yeah, I'd say maybe 3 or 4 weeks so I can look at it and
All right,
figure
if
out what
you
I'm
can look
doing.
at your calendar and give
Sure.
me a date.
Make sure it doesn't conflict with anything important.
Yes, because I know you have the baby in school and everything.
Oh, yep.
I hope she's enjoying life. I know Rachel is.
She finished her summer term with a 98 average.
Oh, that is so awesome.
And her first test in like they have an actual cadaver, like kind of stuff, got a 96. She does not get that from me.
Well, I was gonna say, your wife.
How about October 22nd, Judge? I'll be in town.
It will have to be either the 20th, the 21st, or the 23rd.
Okay. Let's do the 21st.
All right, so Mr. Kianis, we're gonna bring you back on October 21st. If you're still in the hospital, they will let us know and we'll see if we can do a Zoom if that's where you are. Do you have any questions?
Can't wait to see you till then, ma'am. Your Honor,
All right, I hope you get better.
thank you.
All right, do you need to speak to him at
No,
all?
I'm good. Thank you, Judge.
All right, thank you. Is the deputy still there?
Yes, ma'am. I'm still here.
All right, thank you so much. We're done for today.
Yes, ma'am. Thank you.
Goodbye.
Looks to me like you may have had
Well, Vashawn, I come in this morning and I end up getting a major injury. Paper cut. Paper cuts hurt.
They really do. The smallest of cuts hurt.
Oh, yeah.
Whenever you have ready to start then no problem.
Odyssey is moving slow today. All right, oh, I already called him. Let me see. All right, thank you.
So I thought, you know, some kind of board license, but then pretty big. I didn't have to like 8 to 10,000 something. Wow. And so was in his copy was like. Oh.
All right, Bashan. The Harvest Trot, October 12th. We will be there and we need to bring a canned good. 7:30. Oh, we need to let Hank know because he's still. And we probably need to be there earlier than 7:30 so we can get our bib and they say t-shirt. Hello, how's it going? All right.
I've seen the second fifth.
I'm sorry, what? Ah, okay. Well, they had him on Zoom. Yeah. So, all righty.
So today's the.
Thank you.
In the deal. If you look at the- The deal is 2 years to do. But I should invest for this. I don't want. I'll take it before I take it. Okay, this, well. I don't know, chat. But that last. Oh, I should do it. I still gotta do this. I did this. Yeah, well. And only trying to stuff. Yes, so it's very well. It's right here. That's so. Striking. I didn't strike anything, so that's against the law, so against Carlos, yeah. Striking. So basically, everything is the language, but. So. They're all three. How much time do you have in right now? I don't know. 5 months. So if you got arrested on that, you go for 6, so it's 4. Almost like that, 5 months. Yeah. Never been to prison. So. With that. So. I just want to finish it, like, I'll make sure you're understanding. Okay. There's a chance. Just. This is a state. This is true. Correct. That's right. So we have to do the paperwork. Yeah, that's your. Will be flying solo today?
No, Megan and Lauren are in the car, so I heard you down to so far.
This, you're on. And this. This is the. And. Triple so.
Right.
Yeah.
I'll read it, but yeah.
I don't know whether
And could I see the indictment on Carlos Perez, please?
So I rubber banded them by the ones that I'm going to later to and the ones I'm gonna take into consideration, so it should be in the bigger rubber band.
Yes, but I can do.
That's just a bunch of like.
There's a. This to be.
Yeah, that's what it's about.
There's some more. We'd like.
I.
Yeah. We're running with scissors now, aren't we? Thank you, ma'am. Still sniffing. But I'm covered, so nobody working. Okay. I even know it. When I got my vaccine, they said, Scott, it's a girl that works out in the pharmacy. She lives weights where I do, and we got the same trainer, and so she goes, Scott, I know you've also right now, it's very soon. So ride your bike. Do about an hour, I was seeing one of those. So I didn't have to like something. No, I mean, and here's the deal. If I can have the, I think she was, I think I'm getting no, I have one here. Like I was able to get that.
Yes.
We're set for a plea deadline date on October the 16th.
What case is this?
I'm sorry, Judge.
The case?
Oh, the case is Esteban Arena. It's not on the docket today.
All right, so I need,
That's why I'm asking if we, really I'm just asking, do we need to follow? Does the court want us to file motion for continuances on the
Yes.
plea deadline dates?
yes.
Okay.
All right.
Off the record, can I answer this?
All right, who do we have? All right, John Henry Moore. Counsel, I heard you talking about a shot.
Yes, I took my the COVID and my regular flu,
Mm-hmm.
and the lady, the pharmacist that does, I work out the same place she does, she goes, Scott, you always ride your bike this afternoon, you'll feel better. So I rode my bike for an hour and a half and I felt like crap. So,
You know,
hey, by the way, I apologize, Your Honor.
no.
In fact, I'm wearing the mask today for safety purposes, having had a reaction.
Let me just tell you, I did something very silly and I told my mom about it. I remember one time I took the COVID shot and the flu shot at the same time. And my mom is like, Stephanie, you don't even like taking aspirin or whatever. What were you thinking? And I was out for the count.
That's what they're recommending now,
Yeah.
is to get them both at the same time.
Oh, I know.
Got them both.
Yeah.
I remember when they first started the flu shot, I took the flu shot and I didn't take a flu shot after because I was so sick. I was out for 2 weeks. And then my mom begged me, she's like, please take the flu shot. And this was, probably 8 or 10 years after I had first taken it. And then I'm like, okay, I'll take it. And then that time it wasn't so bad. But then I did flu and COVID at the same time, out for the count. Hello,
Got my rabies vaccine also.
Hi, Mr. Moore.
Oh.
Yes. So what is happening with his case?
They made us an offer today. I read it by him, talked with him, and he says he wants to proceed on to trial.
Okay.
And I looked at all the discovery. All the discovery appears to be there. And I will go see him in the weeks to come and start getting ready for a jury trial.
All right. If you will make sure that the acknowledgement of discovery has been signed,
Yes, look at that.
and then Mr. Henry will give you your jury trial, okay?
Oh.
All right. How long do y'all expect the trial to last?
Maybe 3 days tops, I would think,
All right. So Miss
maybe two.
Two. So Mr. Henry, you can have a jury trial or a bench trial. Jury trial, 12 people are sitting on a jury, evidence is presented, and they make a decision on whether you're guilty or not guilty. Or you can do a bench trial. A bench trial, you'll have to agree to it, and the state has to agree to it because the state is entitled to a jury trial as well. But a bench trial is where you come to me. The state will still have to call their witnesses. I will listen, and then I'll make a decision on whether you're guilty or not guilty. So do you want the jury trial, or do you want to speak to the state potentially about having a bench trial?
Jury trial.
All right. Ms. Ferguson, I need a jury trial, family violence, 2 days. All right, so we'll bring you back November 17th. That is the earliest we can take you.
Huh.
Thank you.
That'd be excused.
Just one moment.
Oh.
Let me,
Now remember
Make sure.
that, I gotta get my discovery.
yes,
Hang on a second for that, I'll make
Yeah.
it for you.
let me see.
Was that it?
Oh, yes, that's it. I just need that.
You got, you have it, Thank you, Dad.
You're welcome.
Have a good jury trial.
Well, jury will go the way it goes. I'm sorry, Ricardo Cantu.
Judge, today is the fee deadline.
Yes.
I confer with the state. We have an offer. Mr. Cantu would love to take that, but at this point, there's still videos that are outstanding that the state's going to try to get. So I don't want to delay this, but if we can bring him back. either-
No, where are the videos?
They're hospital videos, Judge.
Your Honor, I can't say for certain there are videos. It concerns me that I don't see any videos at all in our discovery. The reports don't say one way or another that there are, but there usually are at least body cams from the hospital district officers. So I just want to make sure
So does anybody, so.
I'm working on it right now. I just read this report for the first time this morning.
All right, so just give us a moment. So we're gonna see if they can give you your answer.
Okay.
All right, thank you.
Excuse me.
You're leaving us, Rick?
Leaving.
All right, have a good day, Rick.
We'll see you tomorrow.
Okay, bye-bye.
No worries. Lauren, how are you?
Okay.
You okay?
All right, Norma, we're supposed to have a student coming in today. And they have some sort of paper they have to complete. So they're supposed to be here. They said between 11 and 12. So I think we may have completed jury selection. And they're coming to ask questions about what we do for their paper or something. All right. But Norma, we need to make this job sound very exciting and like everybody should want to do it. So everyone, be there for the students. All right, who's on our docket? All right, Christina Canales.
There's a I represent actually the original Sept yesterday, didn't show. I've not had any contact with her.
All right, let's go on the docket. And Deputy, could you make a call in the hallway for Christina Michelle Canales? Court is going to call 2025 CR 009928, State versus Christina Michelle Canales. Could I have parties announced?
Reading Galloway for the state.
Todd Corner from Miss Canales.
All right, this hearing was actually scheduled yesterday on September 23rd. The court called docket at 9 a.m. The defendant did not appear. The defendant did not appear throughout the day and was not here at 5. So the court asked that the case be recalled for today. And it was called at 9 a.m. and the defendant has not made an appearance in the courtroom. Deputy, did you make an announcement?
Yes.
All right, defense?
John, I have not had any contact with her. I had a phone number, I believe, but no response.
All right, state?
We're requesting a bond forfeiture, Your Honor.
All right, the court will do a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider. All right, thank you.
Thank you, my big chief.
Yes.
Thank you.
Rashawn, it's gonna be a long day today. I teach tonight. Yes, so we're doing, we talked about redistricting because I do the campaign and election law. So I'm so happy I was able to get representatives from this, from the Senate and from the House in Texas to come in to speak with the students. Yes, so.
Pretty cool.
Well, you know what? So this is what I do with my classes, because I teach campaign and election law, and I also teach trial advocacy. So we'll talk about a subject matter, they'll get all the law on it, and then I'll have people come in to speak on that field, in that field. So they're very educated on what redistricting means. So now they'll get to speak to the state representatives and ask questions. And what I do, that I always open it up for the public to come, but I tell the public, the only people who are allowed to ask questions are my students. One time we had some people to come, and the people who were speaking were sending me chat messages, you know, just directly to me there. And they said, are people from the public, are these different? I'm like, no, these are my students. My students are, they're going to be educated on the subject
I
matter.
like that. That's
Oh,
really-
yeah.
That's a very unique experience.
Oh, yes, I always do that. And then I always try to get them involved in everything. So I bring different people who they want to come. And I always tell them, everybody from every party, whoever you want to bring, let me know. I'll try to get them. And then I tell them, go out and work on anybody's campaign that you want to work on. And they get credit for that, but it's to get them excited about voting, because that's what I try to do. And then a lot of them say, I want to be a campaign manager. So I have campaign managers come talk to them, and I tell them, hey, unless all of the stars align, you're not going to start off being a campaign manager and making $2 million. But they've enjoyed it, and they always enjoy the trial advocacy portion, because I would have some people say, I want to be a prosecutor, or I want to be a defense attorney. And I said, so defense attorney, you want to do solo practicing? They're like, yeah. I said, it's not like The Good Wife where everybody is walking around in Armani suits, having dinners.
You gotta pay overhead.
Yeah. And getting the client who comes in and says, represent me on this state jail felony. Here's $200,000. I'm like, doesn't happen. But they always enjoy it. And then they get, I do my best to get them internships wherever they're interested. And I try to get them paid internships, because
Who doesn't like that?
but for the campaign and election law course, I always tell them they can sign up to be judges, because they get paid. I want to say it's $15 an hour. So I have somebody come speak to them about that. Because it's hard. It's hard for poor students. Yeah, every little bit helps. So that's what we'll be discussing tonight.
Good on you, Judge.
All right, thank you. Yeah. Well, you say that, but let me just tell you right now, your name is on my list for the trial advocacy and appellate law.
My,
Yeah, I'll say, come in, speak to them. Tell them what you do. But I actually had a former prosecutor from Puerto Rico to speak to them. And so he came, he spoke to them. He said in Puerto Rico, it's different from here because he was actually a prosecutor here. He said in Puerto Rico, you're supposed to go out to the scene with the officers.
like, as a prosecutor,
Mm-hmm. And I know there are some other states and other jurisdictions, the prosecutor actually gets called and they're on call and they go out to the crime scene.
I had seen that where there's like nighttime CID,
Mhm.
CTV that goes out there with
Yeah.
the on-site, like homicide. Or
Yeah.
to look at it. I think that's, it's good. It adds more integrity to the case.
Well, he said, one, it's hard when you get the call at midnight and you got to roll out of bed to go do it. But he said you're able to tell officers sometime, hey, did you get this witness? Go talk to them or whatever. So it's always interesting. In every class I learned something new. So that's always great. Who? Who's he looking for?
I'm here to help as a second chair.
Oh, for, oh, he is in, I think he's in the jury room. Yes. You're welcome. I think he's watching something with one of the prosecutors. Just knock on the door. It's the 187 jury room.
It's my biggest critique of law school
Mhm.
is the complete absence of real world education of practice.
Mhm.
Like, here's the theory. Sure, I could have learned that from a book. I didn't need to spend $200,000 to learn it.
Mhm.
You can learn everything that is in a book. What you really need to learn was practically file a motion. This was before like e-file, right? Everything had e-file, but like how to go and just
See, you know what? That is why,
intimidating
Yeah.
to walk into this whole world without any prior notions.
well, you know what? I started doing criminal law CLEs for the San Antonio Black Lawyers Association because people would label things as, oh, Crim Law 101 foundation. And I said, no, I said, if you're doing foundation, do foundation as though I have never stepped into a courthouse. Can we do that foundation?
Exactly.
And so that's what I started doing. But you were a leg up on me in law school. So anyway, in law school, I couldn't afford books. So I went through all of law school with no books, which turned out to be a great thing. And let me just tell you why it was a great thing. I would look at the syllabus, and on the syllabus, it will tell you what case you're talking about. So what I would do is I would go to the library and I'll be like, man, this case is 500 pages. Because I read all of this, I read the entire decision and I read it from the trial court level all the way up. And that really helped me a lot because I had a chance to understand why the case was decided the way it was. So it turned out to be the best. But yeah, I didn't have any books.
That's in and of itself.
So I would just learn what cases the professor was going to talk about. Then I go to the library and I would read the case. And then I would come back and the teachers would be wondering, oh, she doesn't even have any books. What's going on here? All right, who's here for Oscar Correa Hernandez? All right, if y'all come forward, please. All right, the court is calling 2025 CR 007-803 State versus Oscar Carrillo Hernandez. Can I have parties announce?
Melissa Alvarez.
Jerry Kagan on behalf of Oscar Carrillo Hernandez.
And are you Mr. Hernandez?
Yes.
All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes, Your Honor.
All right, and if you'll state your name for the record.
Jacqueline Payan.
All right, you can lower your hand. Mr. Hernandez, all of the documents that I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
All right, and Mr. Kagan, do you speak Spanish?
No.
All right, and were the documents explained to your client in Spanish through the interpreter?
Yes, they were, Judge. We went through it meticulously.
And counsel, have you received all discovery and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We'll waive it, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Mr. Carrillo Hernandez, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
He most certainly is.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Anyone promise you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, not allowed re-entry, and denied naturalization. Did you understand?
Yes.
And counsel, I noticed on the document, have you addressed all immigration issues with your client, or is there anything you need to put on the record?
We have, Judge, and my understanding is that he also consulted with an immigration attorney.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's $1,000 fine. State recommends deferred adjudication, and there's to be drug testing. Did you understand that to be the plea?
Yes.
And I say drug testing, I mean restitution for the testing of the drugs. Did you understand?
Yes.
Defense is at the plea?
Yes, Judge, and I explained that to him over in the witness room as well.
All right, state is at the plea.
That is your understanding.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a top evaluation, 120 hours community service restitution, and random UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states one in attachment.
I've reviewed those documents with my client. We have no objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We can proceed, Chair.
Anything you wish to say on behalf of your client?
Well, other than the fact that he has no priors and it was a small amount, we would just ask the court to consider following the plea bargain and perhaps cutting down the supervisory fee.
All right, is there any other charges
No.
that are outstanding
No.
against him? So what is happening to? Because in the police report, we can go off the record for a moment.
It got rejected.
So was it rejected?
It was never.
Selection in a
Maybe this
minute.
afternoon.
1:30. All right, is there anyone else ready? Because we have a jury.
Thank you.
You're welcome. Donata. All right, so how long is the paperwork going to take?
She has like 7 cases, Your Honor, so we're trying to get it done, maybe another 15 minutes.
All right. So if you could come back at 1:30, I have somebody here at 1:30. Thank you. Gracias. And then, and then if you could see if they're ready in the back, because we have a jury in the hallway, correct?
We do. I was gonna ask you, so you want to start with the jury, so I can move them back? What do you
Well,
wanna
let me
do?
see if they finish watching whatever video they're watching in the back. And then are they empty next door? All right, because I'm wondering if he could do the paperwork over there and then during break.
Yeah.
They have a full house. Ah. Okay, so here's me asking a lot. See, Bashan, it is so nice when people already know what my response is, so then I don't have to do anything.
Yeah. There's no reason to exasperate the judge.
Oh, hey, it's no problem. Yes, who is Miss Garcia, Attorney Garcia? Get,
Yes, Judge.
on your client, he is not done. They're trying to see if there's a video that exists. If the video doesn't exist, then we'll take him up.
No, I'm for body cam. We're trying to figure out body cam. Is the problem.
Okay. And my understanding is Roberto Ambrosino is in the hallway talking to his client. Could you have them come in, please? Thank you.
Your Honor, what's a good?
But it's only-
The jury trial schedule this weekend for me to catch the prosecutors.
Well, it depends.
It's, well, I can't.
What prosecutor are you speaking?
I'm not sure who's handling it on Monday. That's so is.
Oh,
do y'all
you'll
a
have to
docket?
need to ask them to see who's handling. I don't know.
Do y'all have a docket the rest of the week or y'all just? gonna keep
Yes,
going straight?
we have a docket on Thursday. Yes, counsel.
So they did find some video, Judge. Can we bring them back on the 30th?
Okay, just one moment.
Either the 30th of this month or the 8th of October.
Okay.
This way it's not too long, gives me
Mhm.
time to show him the video.
Norma, on Mr. Cantu, if you can bring him back on September 30th.
Perfect. Thanks a lot.
You're welcome.
Thank you.
Mr. Cantu, we're gonna bring you back on September 30th. If your attorney wants you brought back sooner than that, he'll let us know.
Thank you.
You're welcome. Have a good day. Yes, we're here on Thursday.
Morning docket.
Yes.
And you'll be
But are you off docket? Is it an off docket matter?
Is addressing the matter that's, I just need to see if the state's in, it'll be willing to reset a case if we get hired.
Ah,
That's if not, then we're not gonna take the case.
all right. So you'll need to,
So that's what I was wondering.
is it criminal trial division?
It is, but I understand their headspace is not, to deal with this, so I will come back when y'all are free So that
Okay.
way they have some, I know what it's like to prepare a trial, I'm not
Okay.
gonna, so that's my side. Just what time do you think the court will be resuming trials?
Tomorrow it's gonna be at 1:30.
Okay, so all.
But if you want to come during a break or something, you just have to find out which prosecutor is on it. The two prosecutors who are trying this are Megan and Lauren.
Okay.
So,
Maybe Melissa. Thank you, Ron.
Yes, you can sit right here. Yeah.
yes.
Do we need to be appointed on this case for credit? For the wheel?
Are you on the will?
I mean, I'm a first year staff. I'm just an old
Let
first
me
year.
let me take that up in a moment, okay?
Okay, yeah.
All right, thank you.
Thank you.
All right, Norma, Oscar Hernandez is coming back at 1:30.
Okay. Let's put the next.
Well, I had a couple pre-trial motions. Do you want to do that?
Yes.
For jury selection?
Yes, what are the pretrial motions?
I had two motions in one meeting,
All
and then
right,
a motion to suppress, the video.
all right. So the motion to suppress the video, we can carry that with trial. The motion in limine, what I'm going to, is it something that you don't want brought up during voir dire? What is the motion?
I found kind of an older one. This was kind of more of a traditional one. I don't think you had exceptions to these. Just kind of more of a standard function one. And then the other one was really more about.
Let's see his motions.
Yeah, I have them too. Oh, sorry.
All right, 15 minutes each side.
Oh, we're gonna say.
20.
Fine.
Yes. All right, so it'll be 20 minutes each side. And so the charge here is fraudulent use of possession of identifying information, less than 5 items. Is that correct?
Yes, sir.
All right.
Why don't we?
Lauren, do you have your mic on? No, it's over
Yeah,
there.
yeah, yeah.
Okay,
All right, so Mr. Allen, have you finished with the paperwork? All right, so what we'll do is we will take up your plea at the break of jury selection. Unless, I don't know, Deputy Mejia, Deputy Laura, is there another place where they can go over paperwork?
I don't know.
All right. All right, so Mr. Ambrosino, I don't know if you've been here for jury selection before. All right, so the way we do it is the state will have 20 minutes and then you will have 20 minutes. And I don't do a strike of the jurors in front of the jurors because I always think that's not a good look because then maybe a juror may think you have something against them, right? So what ends up happening after you all have a chance to question the jurors, then you all see what strikes you can agree on. And if you can't agree on it, then we can always call people back up and I'll make a ruling.
Okay.
All right.
Sounds good.
Thank you.
She's around. Which is what I actually.
No, because he's coming to me for punishment if he were found guilty.
Whatever short.
15.
Thank you. Like it will not.
Just make sure the jurors are all fair judged.
Okay. And I'm sorry, you both said that it was less than 5 items, correct? All right, thank you. All right, everyone, please be seated. All right, everyone, good morning. All right, I don't know why there was a bit of a lag time in that. It's early, we're just starting our day. So good morning, everyone. Awesome. So welcome to the 187 District Court. You're on the 4th floor and I am Judge Stephanie Boyd. So what floor are we on?
4.
What's the court number?
7.
Who's the judge? Now, I know what you guys are probably asking. Why would she ask us that? We know where we are. We've been standing out in the hallway waiting to come in. This is why I always have people repeat that and I ask that because sometimes we'll take breaks. And when we take breaks, you can't stay in the courtroom. You all have to leave. Every time we take a break, you got to step outside. And then sometimes people want to take a restroom break. And it never fails. What ends up happening is someone gets lost. And we had to find a juror one time and they were trying to go on another jury trial. And we were like, where are you? And when they come back, we say, well, what's happening? They said, I looked up and everybody was gone. So whenever we take a break, if you look up and everybody's gone, all you either have to remember is the last name Boyd, because I'm the only Judge Boyd in the courthouse, Or if you remember 187th, because this is the only 187th court in all of Texas, because 187 just signifies that this is the 187th district court that was created in all of Texas. So if for some reason when we take a break and you go to another county, again, if you ask for 187th, they will say you should be in Bear County. So that is why I asked that. So I'm going to have the parties introduce themselves to you. This case is the state of Texas versus Carlos Perez. So state, if you could introduce yourself.
Morning, everybody. My name is Lorna Espinoza and I represent. Good morning. My name is Megan Galloway and I represent the state of Texas.
And for the defense.
My name is Roberto Ambrosino. Most people call me Rob. I represent Carlos Perez.
Hi, my name is Thomas Dierina and I represent Carlos Perez.
And Mr. Perez, if you'll introduce yourself.
Hello, my name is Carlos Perez.
All right, thank you. You all may be seated. So, does anyone recognize any of those parties? If you do, please raise your cards. All right, so I'll take that to mean that nobody recognizes them. So, you have cards in your possession. Could everyone please raise your cards for me so that you can get in the habit of raising them? All right, and when you raise them, always make sure that your numbers are facing towards us because that is the way the state and the defense will be able to identify you. Does everyone understand? All right, you can lower your cards. We're going to practice with people raising their cards. On my left is the court reporter. She takes down everything that everybody says. So, as you can tell, that could be a difficult job because some people speak very fast, some people speak very slow, some people whisper, and then sometimes people start having a conversation and you think you know what the question is going to be. So before the question is even finished, you start answering the question. Well, when we do these things, that makes her job more difficult. Now, will she be able to take down everything that everyone is saying? Absolutely. But the question becomes, do we want her job to be difficult today on this beautiful Wednesday, or do we want it to be easy? So raise your card if you want Cindy's job to be difficult today. All right, so nobody wants her job to be difficult. This is how we can help her out and make her job not difficult. So everybody raise your card. When I call your number and ask you to lower your card, I want you to lower your card. So jurors 1 through 14, lower your cards. Jurors 15 through 21, lower your card. 16, you can lower your card. All right. So everyone else, to make Cindy's job easier, if somebody asks you a question and you're replying, if you can, I'm going to need you to stand. Can everyone promise me that if you can stand, you will stand when you are answering or asking a question?
Yes.
All right, you can lower your cards. I'm going to tell you what I tell every jury. Every jury that is called up, they say they can follow those instructions. We have a jury trial in this court every week, and that's been since 2019. So, how many jurors do you think have been able to follow that instruction? 0. But I'm going to tell you what I told those jurors. I have faith that you will be able to do that. So let's make her job easy. Now, in this case, or I should say easier, in this case, the charge is fraudulent use or possession of identifying information less than 5 items. The state and the defense are going to have 20 minutes each to speak to you. They are not allowed to tell you what they think the facts of this case are. The only thing they're allowed to speak to you about are hypotheticals. They can tell you what the charge is, but everything else has to be in hypotheticals. So don't be like Mrs. Kravitz from Bewitched and think that something means something that it doesn't. Does everyone understand? Even when I'm speaking to you, I'm going to be speaking to you in hypotheticals. The only way you will know what people think the facts are in this case is if you are selected to be on the jury. Does everyone understand? Yeah. Now, I want to talk to you about an indictment. What is an indictment? What does it mean? An indictment is just a piece of paper. That's it. It's a piece of paper, and it tells somebody what they're being accused of, and it tells them where they need to be to answer for the accusation. Does everyone understand? So let's practice raising our cards again. How many people here have ever had a traffic ticket? All right, so I will tell you this group, worst drivers we've had, because I asked them this a lot of times. So I've had a traffic ticket before, and I want to say I was about 19, maybe 2021. So here I am, 22 years old, and that's a fond memory. So when you receive a traffic ticket, the year I received my traffic ticket, it was when they had the paper tickets and they had the carbon paper. And I know young people like, what is carbon paper? But they would write down what they said you did, and you would get the carbon copy, and they would keep the original. And on that carbon sheet of paper, it will say what they're accusing you of doing. For example, let's say your traffic ticket is, they're saying you ran a stop sign. So you get the ticket, and they say the officer checks off the box that says ran stop sign. And then at the bottom, it'll have a date for you to appear at municipal court. And for this hypothetical, let's say it's the municipal court that's on Frio Street. So you go there, you pay for parking, you're upset about paying for parking. And when you go there, you know that you're going there because you've been accused of running a stop sign. When that officer gave you that ticket for running the stop sign, your accepting of that ticket is not saying, officer, you're right. It's just putting you on notice of what he's charging with. Wouldn't it be a shame if you were to take that ticket to municipal court and surprise, you're in a jury trial, but it's not for running the stop sign, it's for running a red light. It's like, I didn't prepare for this, right? So that ticket is just a notice. It's not evidence of anything. It's not evidence of guilt. You're accepting it as not evidence of guilt. It's just to let you know what you're being accused of. And an indictment is not evidence of guilt. It's not evidence of anything. It's just to let somebody know, hey, this is what you're being accused of, and this is where you go, and this is the date where you need to be there, so you can answer for the accusations. Does everyone understand? So it's not evidence of anything. It cannot be taken as evidence of anything. Does everyone understand?
Yes.
Is anyone going to hold it against Mr. Perez because he is here under indictment? All right. And the other thing about indictments, when I say it doesn't mean anything, you can't take it to mean as anything. You can't even consider it if you begin deliberations in a case. So you can't be in the back and say, oh, this person was indicted. Can't consider it at all. In fact, the indictment is just notice to the person who's being accused. It's not notice for you. Does everyone understand? Yeah. All right. Next thing I want to talk to you about is the right to remain silent. Everyone has a right in criminal cases not to be called as a witness. So for example, someone, and when I say right not to be called as a witness, I mean someone who's accused of an offense. So the state can't say, next we would like to call the accused, because the accused has the right to remain silent. So what does that really mean? That means that you don't have to testify if you don't want to, but it's your right. You can make the choice to testify or not testify. If someone decides not to testify, can't hold it against them. You can't consider it whatsoever. There are many reasons why people will not testify or make a decision not to testify. I've been a defense attorney. I've been a prosecutor. Sometimes the reason people, just one second. It's okay. Sometimes people choose not to testify because maybe they're afraid of speaking in public. Maybe they have some type of speech impediment. Maybe their attorney or counsel told them, look, the state didn't prove their case. There's no reason for you to testify. There are many reasons. I remember sometimes I would have clients, I would tell them, I can't put you on the witness stand. My advice to you is not to testify because I'm on your side and I'm asking you questions and you're sweating. You can't look directly at me. because people will always ask you, how do you determine whether somebody's credible? And what do people usually say? Oh, are they sweating? Can they look you in the eye? Are they acting nervous? And sometimes that may be the case, maybe not. So the key thing is no one can have it held against them if they choose not to testify. Sometimes you'll have citizens who will say, well, if that were me, I would want to tell my story. And I always chuckle inside when I hear that, because I'm like, yeah, but that's not you. And maybe you don't have an expert or an attorney who's telling you, don't do it. So the question becomes, is there anyone here who would hold it against Mr. Pettis if he decided not to testify? If that is you, raise your card. All right. The next thing I want to talk to you is burden of proof. The state has the burden of proof in this case. They have to prove their case, each and every element beyond a reasonable doubt. What does that really mean? What is the definition of proof beyond a reasonable doubt? When I first started practicing my very first trial, I knew the definition. I still know that definition to this day because you had to learn it backwards and forwards. I knew where to put the commas. I knew where to put the exclamation point when I was talking about it. I knew when to pause for dramatic effect. But after I had my very first jury trial, you know what happened? There was no more definition for proof beyond a reasonable doubt. So neither the state nor the defense can tell you what the definition is because there is no definition. So when I was a prosecutor and defense attorney, I had to think, well, how am I going to explain this to everybody? And the best way I could explain it to them was by telling them what it was not. Next door, the courthouse with the green rooftop, that's our historic courthouse. They handle civil cases there. Their burden of proof, for example, if there is a car accident, their burden of proof is preponderance of the evidence. What does that mean? That means more likely than not, something happened. So if you're ever deliberating in a criminal case and you're talking to jurors and somebody is telling you, well, I believe this happened more likely than not, you need to immediately ding, 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 and click in your mind and say, wait a minute, we're not in the historic courthouse, so that shouldn't be what we're discussing. The other burden they have over there is something called clear and convincing evidence. Clear and convincing evidence is their highest burden over there. And that's the burden that's used to terminate somebody's parental rights, where they're saying you will not be a good parent, you will be a danger to this child, so we will no longer allow you to parent the child. Does everyone understand? Those are their highest burden over there. The burden that's even higher than that is proof beyond a reasonable doubt. Does everyone understand? Now, the next thing I want to talk to you about is fairness, because you'll have people ask you questions. Are you going to be biased? Can you be fair? Really, what does fairness mean? Usually people will give you a hypothetical, and this is the hypothetical I've seen people use. They will say, you know, you have jury duty coming up. So you plan your route, you map out where construction is going to be, you map out where the parking garage is going to be, you have the exact change for parking, you're good to go. And you even go so far as to drive the route the day before because you want to be on time. So on the day that you're supposed to come down for jury duty, you're at Smell, you got up early, you had your breakfast, you go downstairs, and your car is on cinder blocks. Somebody, oh, see, I just brought it down, right? Everybody's like, no. So your car is on cinder blocks, but you want to do your civic duty. So you either get an Uber or your next door neighbor, you take the Via, you come down. And when you're called up for trial, you find out that the case you're hearing is a burglary of a vehicle. And then people will say, can you be fair? And usually people's knee-jerk reactions like, no, I can't be fair. But here's the proper question in that case. The proper question is, even though hypothetically it's a burglary of a vehicle, and your car this morning is on cinder blocks, will you be able to listen to the evidence and base your decision on whether someone's guilty or not guilty? If you can come to the decision based upon the facts that you hear, or are you going to say, you know what, that person is being accused of burglary of a vehicle. I don't care if they did it or not. I'm going to just find them guilty. Does everyone understand? So that's what fairness is. Fairness is whether or not you can listen to whatever evidence is presented to you and base your decision, if you can come to a decision, on the evidence that you hear. Does everyone understand? Yes. Okay. So this is what I always tell jurors. Raise your card if you were born yesterday and slept all last night. All right. So nobody was born yesterday. And the reason why I asked that question is because we all have things that have happened to us in our past, right? But that's called life. So the main thing about this case is whether or not, even if you've had something that has happened in your past, whether or not, if you're selected for this jury, will you be able to listen to whatever evidence is presented and make a decision, if you can come to a decision based upon the evidence that you hear? Is there anyone who is unable to do that? All right. Now, the next thing I want to talk to you about, in criminal law, there are two phases to every criminal trial. First phase, people love to call it the innocence phase, but it's not. Phase one is really, did the state prove their case beyond a reasonable doubt, or did they not prove their case beyond a reasonable doubt? That's phase one. If you find that the state didn't prove their case beyond a reasonable doubt, what should your verdict be? Okay, again, I'm getting mumblings. All right. So right now, how much evidence have you heard in this case? So what if you had to decide on this case right now, what should your verdict be? All right. So now, if you are on a criminal jury trial, and if you find that the state has proven their case beyond a reasonable doubt, that would mean a guilty verdict. Then you would go to phase two. And phase two is the punishment phase, and that's where you decide what the appropriate punishment should be. In Texas, there is a rule, and the rule is that anyone who is having a criminal jury trial has to make a decision before jury selection that if they were found guilty, who would decide their punishment. It's the law. So when somebody makes that election, they are not saying, oh yeah, I'm guilty. No, it's just the law that they have to make a decision before jury selection. If they were found guilty, who would decide punishment? In this case, Mr. Pettis has decided that if he were found guilty, the court would decide punishment. Is there anyone who's going to hold it against him that he has decided that if he were found guilty, the court would decide his punishment? Now, the next thing I want to talk to you about is languages. I love languages. I think they're beautiful. When I was in junior high, I know y'all call it middle school now, but elementary school and junior high, mainly junior high, we had to pick what language we wanted to study. They just brought different languages in school, and we were the test cases for different languages. So, of course, being from Louisiana, knowing that I was going to be retired by 21, knowing that I was going to enjoy my time in Paris, I chose the only language that I should have chosen. My friend said, Stephanie, take Spanish with me. I said, never gonna need it. I have my life mapped out. So I chose French. And lo and behold, I ended up going to law school here. And so now I'm here learning the Spanish language. So I think it's great. I could probably say hurry up in many languages because all the students that I went with, that I don't want to say went with, that's not the proper term. All the students that I met in undergrad, grad school, and law school, they spoke a lot of languages. And depending on where they were from, I met someone who spoke 6 languages. So I have learned to say hurry up in almost every language. That was easy for me to learn. Other things, much more difficult. My friend taught me Navajo, Farsi, you name it. So I can say hurry up in every language. But what I need to know from you is I need to know, raise your card if English is not your first language. Oh, so just raise your card. So we have number 9, 22, 27, 36, 39, 53, and 62. All right, so you all are sort of like the test subjects because people are sort of timid. They're like, I don't know if I should raise my card. But they're going to see nothing happens to you when you answer my questions. Then everybody's going to answer. All right, juror number 9, what's your first language?
Spanish.
All right, have you been able to understand everything?
Yes.
All right, thank you. 22. All right, don't fail me. Yes, you remember we're making the court reporter's job easy. All right, what's your first language?
Spanish.
Have you been able to understand everything?
Yes.
All right, thank you. 27. First language?
Gujarati.
Ah, can you spell that for the court reporter?
Gurati.
All right. And how do you say hurry up in your language?
Jaldi karo.
All right, I'm gonna work on that. Have you been able to understand everything?
Yeah.
I'm sorry?
Yes.
All right, thank you. 36. First language?
Spanish.
Have you been able to understand everything? Thank you. 39. First language?
Spanish.
Have you been able to understand everything? 53.
Yes, ma'am.
First language?
Arabic.
How do you say hurry up?
Sorry.
Sarah. Okay. Have you been able to understand everything? Thank you. 62. Yes. First language?
Spanish.
Have you been able to understand everything?
Yes.
All right. Thank you. You may be seated. All right. So I expect this trial to be concluded at the earliest, probably Thursday, at the latest, Friday. Does anyone have any time constraints? Some sort of non-refundable tickets? What happens when I ask this question, people will give me dates from December, mainly because they want to tell everybody about their exciting trip and want us to be jealous, and we are suitably jealous. So raise your card if there's some sort of time constraint. All right. And once I call your number, please lower your card. 9, 16, 19, 21, 28, 42, 48, 49, 50, 56, and 65. Number 9, what's your time constraint?
Oh, sorry, Your Honor. Just to clarify, is it tomorrow and Friday that you meant?
Yes.
Okay, can you write me off that list, please? I
All
am
right, thank-
available for tomorrow and Friday.
All right. And then just so everyone know, we're going to start this afternoon once the jurors are selected. All right. Thank you. Number 16.
My daughter is having surgery on her eyes.
And when?
Friday.
Do you know what time?
I think she said it was 8 o'clock in the morning.
All right. Thank you. So if it's 8 a.m. in the morning, that means they won't start till 10 or something, right? Number 19.
At 2:30 today, I have to go meet my probation officer.
All right. Thank you. Number 21.
I'll have custody of my daughter Thursday at 5, and then Friday I'm going to Fredericksburg.
Oh, okay. See, she wants us to be jealous. So what are you doing in Fredericksburg?
It's just in Fredericksburg.
Oh,
And
okay.
every.
I thought you were the person who won the lottery from Fredericksburg.
No.
Okay. All right. Thank you. Number 28.
I'm a pallbearer for a funeral in Houston on Friday.
Sorry to hear that. Thank
Thank
you. Number 42.
If it's this week, I don't have any constraints. It's not till next week. So
All right. So did you want to tell us about it?
I've got to go to Tampa for work.
Oh, okay. All right. If you want to throw that work party in, we'll believe you. Number 48.
I buy produce for HEB and I only bought, no, I buy the salads and I only bought enough to cover today.
Oh, okay, so you buy the produce for HEB, the salads?
Yes,
All right, thank you. And I'm sorry, when is this? Is this every day?
this is every day. My coverage is out of the country, so I was able to cover it today. But
All right, thank you. Number 49?
I'm driving my mom to New York for injections for her spine.
All right, everything is gonna go well. And when are you doing that?
Tomorrow, she has to be there at 10 and she'll be there until 12:30.
All right, thank you. Number 50?
So I have to pick up my son for school and my mom's the only transportation, so she's leaving to Mexico tonight, so I won't have anybody to pick him up.
All right, and when is pickup?
3.
All right, thank you. Number 56?
Your Honor, I'm an entertainer and I'm booked for Thursday. That's my only profession.
And what do you do for entertainment?
I'm a magician.
Oh. What are you, we're waiting. Number 65?
Your Honor, I'm good for all day today, but I got a doctor's appointment tomorrow. They're adjusting my blood pressure pill, and we got a trip to Austin, and I have an interview for a new job as well tomorrow.
And what time is the doctor's appointment tomorrow?
10 a.m., ma'am.
10 a.m. All right, thank you.
Thank you.
You're welcome. Cindy, do you need a cough drop? Oh, wait a minute, just one second. So she's juror number 20? Yes.
For work meeting tomorrow from 7 to 3. That I can't miss, but other than that,
And that's tomorrow?
yes, sir.
And that's 7 a.m.? All right. All right. Now, see, this is what happened. People see that nothing happened to anybody. Now the cards are going up. All right, 36?
Yes, Your Honor. I'm just want, I don't know if this, I'm a pediatrician. I have patients scheduled all day tomorrow and Friday. I mean, they can be rescheduled, but that's a fact.
All right, thank you. Anyone else before we move on? All right. So I'm going to tell you all 2 stories, and both of these stories are true. My family grew up in a small town called Grand Cane, Louisiana. People can usually tell that I'm from Louisiana when I have to say words like all and soul. And so my uncle, super intelligent, and he was my grandmother's firstborn. So he would go to school, and that was back in the day where all the teachers knew every student, not just the student in their class, but all the students of the school. And so they would skip him, and they would tell my grandmother, they would say, Miss Lane, we've taught him all we can teach him. There's nothing else for us to teach him. So when his sisters and his brother go to school, they're a little bit unhappy with him because the teachers tell them, we're going to expect a lot out of you guys because your brother, he's raised the bar and he's the gold standard. So my uncle ends up graduating. And when he graduates, the Vietnam War breaks out. And he goes to my grandmother and he asks for her to sign for him because he says with civil rights and everything that's going on, there is no way for me to improve my lot in life here. And I always tell that story to tell people that jury duty is an inconvenience. My grandmother and my uncle had to make a sacrifice. And so what ends up happening is my grandmother signs for him to go. She has his name and his army number, and she's able to write letters. And so for young people, they had to write letters. None of this email thing, none of this texting, because it didn't exist. My grandmother did finally have a television, and you have only 3 stations, ABC, CBS, NBC. NBC, you really couldn't count on because believe it or not, if there was a slight breeze, you're going to get static. If there is a strong breeze, you're not getting anything. So the weather had to just be perfect. And she had the little rabbit ears you try to adjust, and you had the antenna on the house. And then programming would end. So to the young people, you use this 24/7 thing. No, programming would end. And how you would know it would end is the television would just go white with the static, or either when they got high tech, they would play the national anthem and the flag would just be blowing in the wind and you'd wait for programming to begin the next day. My grandmother did have a phone, but it wasn't a touch tone or a rotary. So to the young people, you needed those numbers in order to dial the rotary. And if you were trying to win a prize, it hurt your finger because you're trying to dial real fast, but you're just waiting for it to turn back so you can get the next number. She would just pick up the phone and the operator would answer and you would tell the operator who you would want. So that's why you would have songs like Beechwood 45789. And my mom tells me that they would play on the phone whenever there was a new song that came out with a number on it. They would pick it up and the operator's like asking them who they want. Beechwood 45789. And you know, the operator's like, doesn't exist. So that's a sacrifice. So she sent off her firstborn. And I know parents will say, I love my children all the same. But there's something about the firstborn because that's the child that you're practicing on. And so she sent him off and she would write a letter and she'd have to wait for a response to come back. And of course, it would take some time. My grandmother had a 6th grade education, but she was super intelligent. She babysat me when my mom would work. And so by the time I went to school, I already knew my ABCs. I knew how to read. I knew how to write. I knew how to tell time because young people didn't have this digital thing where you just look it out on your cell phone. You had to look at a clock, much like on the wall, and know how to tell time. But one thing she realized is that you did not want somebody in military dress coming to your home. So I would always end that story there. And then Deputy Laura's like, in Deputy Mejia, Judge, you can't end it there. Like, what happened? They were like, what happened to your uncle? So my uncle has since passed, but he did make it back from Vietnam. And I always tell that story because sometimes I'll see jurors, or sometimes people want to get out of jury duty. And I tell them your country only asks 2 things of you. They ask for you to pay your taxes. They don't even ask you to vote. They ask for you to pay your taxes and show up for jury duty once in a blue moon. And I always see people, Memorial Day, Veterans Day, 4th of July, everybody want to wave a flag, put a yellow ribbon on a tree. But when your government asks you for this one thing, you can say, do it for the troops. It's just do jury duty. Raise your card if you have ever served on a jury where you actually listened to testimony. All right, so that is jurors 4, 29, 30, 51, 52, 57, 61, and 64. You can lower your card. So as you can see, that's not that many people. And it's not like your government calls you up every 3 months to serve on a jury. It's once in a blue moon. So I tell that story to tell people this is a part of your civic duty, sitting on a trial. In order to have jury trials, we need jurors. Now, the other story I'm going to tell you is concerning my friend. She decided to do civil law. I always loved criminal law, and that was my passion. So one day, she calls me and she says, hey, you want to do lunch? I have jury duty. I was like, yeah, let's do lunch. This is great. We haven't had a chance to have lunch in a while. So we're having lunch. And I say, hey, how's jury selection going? She was like, going fabulous, fantastic. Now that I'm a judge, I'm like, how can it be fantastic when she wasn't having jury trial with me? But that's another story. So I say, what do you mean that it's going fabulous? It's going fantastic. And she tells me, oh, I'm not going to get selected because it's just like law school. I'm in the back. I'm being quiet. I'm not saying anything. So I start laughing and she's like, why are you laughing? I'm like, I'm just so excited because we're going to have lunch together all week. And guess what? We had lunch together all week because she ended up on the jury. So other than raising your card saying, please place me on this jury, the quickest way to be on this jury is if you are silent. And I tell you that because each side is going to have 20 minutes to speak to you. They don't have time to go to your house, go in your backyard, have dinner with you, go on vacation. They just have 20 minutes and that's all. So states, you may proceed.
I'm not sad. We'll start again. How is everyone doing today? That's a little better. I appreciate the sarcasm from you all. So we are going to talk about the law as our main goal, but we do have a few things I want to cover. So like I stated, my name is Lauren Espinoza. I represent the state of Texas. I have a few quick rules. I know this might feel a little bit like school, right? So the first rule, like Judge said, we can't talk about facts. Number two, I ask that you be honest with me. We don't have to agree with each other, but as long as I can learn your honest feelings, we might determine that you're not the right juror for this case, and that's fine. That's what we want, okay? We ask that you participate. That's number four. And then most important, I would think, is that there are no right or wrong answers. That ties into being honest, and it's okay if you don't agree with what I'm saying or the law, but we just want to know that, okay? Can everybody agree that we can follow these rules? Yeah, okay, along with rules, we're gonna talk about our goals. We wanna talk about the law, we wanna learn about y'all, and we wanna pick 12 fair and impartial jurors that are right for this case. So here are our elements. Our elements that we have to prove to you in this case are on or about a date in Bexar County, Texas, the defendant possessed less than 5 items of identifying information without our complainant's consent, with intent to harm or defraud. Your eyes are probably glazing over. You're thinking, oh my gosh, that's a lot of info. What does that mean? It's okay. We're going to break it down. So first, we're going to talk about identifying information. The code defines it as information that alone or in conjunction with other information identifies an individual, including name, social security number, date of birth, government ID number. There's this biometric data, retina image, voice print. That's kind of high tech. That's beyond my pay grade. Unique electronic identification number, address or routing code, and telecommunication identifying information or access device. So that's a lot of info. So based on what you see up there and what I just said, what kind of items might contain this information? Does anybody have ideas? Raise your card. Y'all just stand up here. Number 5. An ID. An ID. Okay, what else? Number 7. A bill. A bill. What kind of bill? What kind of info might be on that utility bill?
Well, if it's for cell phone, potentially have date of birth or other, for information.
Yeah. Yeah. What else? Number 40.
Insurance card.
Okay. What about an insurance card? What would be on there?
Member ID.
Okay.
This is my PHI.
Okay.
Birth certificate.
Birth certificate. Yeah. Okay. Who else reads 47?
A computer.
A computer. Okay. 33.
The bag that you get at the pharmacy when you pick up a prescription.
Mhm.
That's identifiable.
The information would be contained.
Name, address, the type of medication you're taking, dosage, date of birth.
Okay, 34.
Would a phone fall under that?
A what?
A phone,
Ah,
since like the face scanner and stuff like that?
yeah, in that sense, yes, but just a phone in general, I can't hold up and move. This is my identifying. It might contain inside, but the phone in of itself, no, but the scan is good. 29.
Bank information?
Okay, bank information. What do you mean?
Well, it has your name, your date of birth, social security number, your routing number. Has all that information.
Okay, you're talking about the account specifically or
The
like a
account,
statement?
the account specifically.
Okay, what about a bank statement? What info is on that? You're not in your head. What's your number 4?
A routing number and
Uh-huh.
their address, name,
What, 12?
Sounds like a phone number.
A phone number? Okay, maybe. 24?
Passport.
Passport would be a good one. Is that 44?
Well, how much money you have?
How much money you have? Not quite. That wouldn't identify just a number in and of itself. Okay, 34 would be our last one. We're gonna move on.
I would like car registration.
Our registration depending on what info's in it, right?
Address.
Mhm. Okay, one more 55.
Your W-2
Okay, what about a W-2?
has everything in both name, word, address, or income.
What about checks? Who agrees a check might have identifying info? Yeah, what info's on a check? Right, so we can all agree that has identifying info within it? Okay, perfect. So next we're gonna talk about possession, right? That's one of our elements, that the person possessed that identifying info. So under the penal code, that means actual care, custody, control, or management. That doesn't mean that it has to be the actual owner. Does that make sense? So here, I have this laptop that's been issued by Bear County. It has a sticker on it that says property of Bear County. However, I take this laptop with me everywhere, right? I work all the time, it's with me, I put it in my bag and I go home. Am I the owner of that laptop? No, but do I have possession of that laptop?
Yes.
Yes, okay, so does that make sense to everybody what our definition of possession is versus ownership?
Yes.
Yeah, okay, perfect. So here we're gonna talk about mental states a little. So intentionally, you act with intent when it's the actor's conscious objective or desire to engage in the conduct or cause the result. Okay, and then knowingly, someone acts knowingly or with knowledge when the actor is aware of the nature of their conduct or that the circumstances exist surrounding that conduct. Does that make sense? Everybody good on that? Have any questions about those two? Of which? Knowingly? Okay, so say let's see. Okay, so say I want to take my okay, I have a lot of work, right? I have a lot of work I need to do. I know that I have trial coming up. In order to do that, I need to work on my laptop to do my board diary presentation. I decide, you know what? I know I need to use my computer at home, but I can probably work on my home computer instead. So I leave my laptop knowing all of my evidence and everything is downloaded onto this. I then go home, I go sit down to do my board diary, and you know what? I need the officer's report. What computer is that on? My work computer, right? But I left the building knowing that all that info was in that computer, but I still left the office without it. Does that make sense? I knowingly left my computer. Does that make sense? Does that help a little? I still acted anyway, knowing all of my evidence was on here. I know that if I go home and don't have this information, I might not be able to do what I set out to do, which was do my work. Does that help? Okay. So how do we prove intent? We have some spoilers there, right? Circumstances. Yeah, everybody agrees circumstances can prove intent, maybe admissions, statements. So you can make reasonable deductions based on words and conduct, right? If you see someone do something or say something, you might be able to make an inference of what their intent was, right? What their goal was, what they meant to do. Does that make sense? Everyone kind of on board with that? Okay, let's talk about consent a little, because one of our elements is that it was without the consent or effective consent of our complainant. So consent, right? Usually the owner can give consent. So who is an owner would be the question. A person who has title to the property, possession of that property, whether lawful or not, or a greater right to possession in that property than the actor. And then also effective consent. This includes the consent by a person legally authorized to act for that owner, right? So that's how you can get consent. How do we determine non-consent? What are signs of that? Who has an idea? 51?
Documentation.
Documentation of non-consent, what would that look like? Yeah, like
I can't.
can you stand up?
You are or you aren't allowed to use
Mhm.
specific documentation.
Okay, what else? Who has an idea? 60?
When you leave the hospital, they have you sign a letter of, this consent, whatever, where they can leave and not be responsible.
Okay, what else? 20? If the property was stolen. If the property was stolen, okay, 48,
Unconsent could be anything where you don't explicitly give consent.
where you don't explicitly give that consent. Okay, what might that look like?
A lack of consent. If I leave my car outside unlocked, someone takes it. I never, just because I didn't say, hey, I don't consent to you stealing it.
Mhm.
I'd still be upset if they stole it.
Right.
Be a lack of consent for someone to take my car.
Right, the action of locking it would show that I'm securing my property. I don't want anyone else to access it,
Or just by saying,
or even unlock.
yeah, just by leaving. Was not, that was not consent.
I'm gonna jump in really quick, since you're an employee with HEB, right? If you go into an HEB store and let's say the produce, right, all of it has like price tags and everything like that, right? And so non-consent would be, well, going back to knowingly, who had the question about knowingly? Number 61. Okay, so when you go into HEB, right, they don't really have signs that say like, hey, you need to pay for the items that you're gonna take out of here. But when you walk into HEB, you see the prices, you know that you're not the owner of any of the property in there. You see that they have cash registers, and you know that if you're going in there, you're going in there to buy something and that you have to pay for it, right? And so there are not any signs in the store that say, you know, HEB is not giving you consent to take this, but it's inherent, right? Can everyone agree on that? Does anybody disagree with that? Okay, does anybody have any questions about that? Okay, so I was kind of picking on you.
Sorry, you just said there's no signs, but aren't there signs in the store that say?
Oh, I'm sorry. You're gonna have to, let me pause time for a moment.
Oh.
You're gonna have to, guys, you have to make her job easier. So stand and make sure you keep your voice up so that she can hear and everyone else can hear.
No, yeah, can you hear me?
Yes.
Cool. I was saying that she said there's no signs, but when you walk in, there's signs that say you'll be prosecuted if you steal, no?
I don't recall, but if you do.
I think every store has a sign that says something like that.
Okay, you can go ahead and have a seat.
Of course.
Just to touch base on the items in HEB prices. There are some of the HEB has on the app free item.
Oh, like through the app, like with a coupon or something? Okay, but you just can't walk in and take it, right? You have to go through the register and like scan the coupon and everything, right? Okay, perfect. Moving on, I'm gonna hand it back to her.
Okay, so let's talk about our burden a little. As Judge stated, that is what we must meet, right? We embrace this burden. There are multiple. But there is no definition, right? So that makes it a little tricky. So what I can tell you is that it's beyond a reasonable doubt. That doesn't mean it's beyond all doubt. It's not beyond a shadow of a doubt. It's not 100%. Now, I want you to remember, while something may be possible, it may not be reasonable. Does that make sense? Yeah? Okay, so who can tell me what this is a photo of?
Jigsaw puzzle.
Read your card. 23? Did you have something? No. You're just stretching, you don't want to participate, I think 38?
Jigsaw puzzle?
Okay, what is it a jigsaw puzzle of? 2. Giraffe? How do you know?
I can tell.
How? Are you a clairvoyant? What about our magician? What is it? No? Okay. You are right. Number 2, it is giraffes. So even though we have some missing pieces, right, you can still determine that it is this photo of giraffes. Who here can say beyond a reasonable doubt that this is actually a photo of frogs? Right? It could be possible that it's another animal when we look at it like this. But is it reasonable once all the most of the pieces have been put together to say this is frogs? No, right? Okay. So evidence, let's talk about evidence. What kind of evidence would you expect to see in a trial? 45? Photos. Okay, what else? Y'all are awfully quiet up here. Let me see your numbers. Number 7. What kind of evidence?
Physical, tangible.
Maybe. Okay. Phone a friend. Number 5.
Video.
Okay. Number 11.
DNA.
Maybe not in a fraud use possession ID info, right? Number 12. What about a fraud use possession ID info?
Just like a verbal thing.
A verbal statement. Number 9.
Depending on the item, maybe a report that something was stolen.
A report of something stolen, depending on the item. Okay. And then number 8.
Audio, some type of audio. Like
as a party or a percent.
Okay. Okay, those are all good ideas. So let's talk about direct versus circumstantial evidence really quickly. You can tell me what direct evidence. Any ideas? 30?
Wouldn't that the example you gave earlier of a check,
Mm-hmm.
that would be more of a direct physical form of evidence versus circumstantial, I would think is something that you might not have physical. But it's maybe something that, you know, he said, she said. Kind of.
Mm-hmm. Yeah, that's a good example. Okay, what about circumstantial? We got some he said, she said. Do y'all want an example of that? About how circumstantial evidence? Yeah, so I'm gonna give y'all one anyway, after 22 talks. A witness? A witness. Okay, direct evidence through a witness. Okay, so let's talk about circumstantial evidence a little bit. So I have a roommate. My roommate happens to be my sister. And in our shared fridge, I have some leftovers that I've been thinking about all day. I can't wait to get home and eat. Okay, I know that I go to work in the morning and my sister is off. I know y'all know where this is going. I can sense it in your eyesight at me. So I go to work. When I come home in the afternoon, knowing that my sister went to work in the afternoon, so we have split shifts, right? I go home and I see in the sink, there's my bowl, my blueprint bowl, and you know what? My leftovers are gone. Now I didn't see my sister eat my leftovers, but I see my bowl, and the last time I saw it, it was in the fridge. I'm like, that pesky sister, let me check our Ring camera. Did she have anyone over to eat my leftovers? Like, what happened here? Nobody came over to our house. I didn't see her eat it, but my bowl is there. That would be circumstantial evidence, right? That my sister ate my leftovers. Does that make sense? Yes? Okay, perfect. Let's talk about witness credibility. So jurors are the sole judges of credibility in a trial, right? We can't prejudge a witness because of who they are or what they do. And y'all get to decide as the fact finders who and what you believe. Okay, y'all have to wait, watch, and listen to everything that's presented as evidence before y'all. Can everybody agree to do that? Yeah? Okay, so let's talk about police officers. Will anybody hold it against an officer that he or she is an officer in and of itself, right? So maybe you have bad experiences with officers, right? And you're like, I don't like all police officers. All of them are bad. All of them are crooked. I don't know what this officer is going to testify to. I don't know who they are, but I don't like that they're wearing that blue uniform. Is there anyone here that will not be able to be fair and impartial in listening to an officer just because they're an officer? No. Raise your card if you. Okay, so everybody can agree they will be fair and impartial and listen to what any potential witnesses would say. Yeah. Is there anybody that's had a truly negative experience with an officer? Raise your card. Number 40, if you would feel comfortable, could you share a little bit about that experience?
I guess 20 years ago, had I pulled over for DWI, and I didn't think I was under the influence, but I was treated like I was, and something I'll never forget.
Okay, so in light of that experience, do you think you'd be able to set it aside and be fair and impartial in this trial?
I think I can.
You think you can?
All right, 2 minutes.
Thank you, Judge. Number 5.
Yes, I'm about to say that.
No, you.
My incident happened when I was really young.
Mm-hmm.
My boyfriend at the time was pulled over, and I was told to exit the vehicle. And because we were going to a concert, the police officer automatically assumed that I was, I don't want to say this, but something else that I wasn't. And the whole time he just racially profiled me the whole time because my boyfriend was white and I was not. And I was wearing an outfit appropriate for a concert.
So thank you for sharing that for one, but because of that experience, do you think you would be able to set it aside and be fair and impartial in this trial? Yes, okay. Is there anybody else? Number 15? Running center. Did Judge tell you so?
Oh.
Okay.
I can't see her.
She's 15. Can you please hold your card?
Of course. Me and my husband, we had just left the grocery store. We had bought a few groceries we put in the trunk of the car. And And it was the same area that this one store got robbed. And the description that they had was our car. And they pulled us over and, they were rough. They rough handled us. And, I just had knee surgery and they had put me to the ground and my husband got angry with them and they didn't care what he said or what was going on. They wanted to know if we stole that grocery. And I told them the receipt was in the front end and they went and got it and they didn't care about it. And then at the end, they didn't even apologize or say anything. I mean, we were free to go. And yeah, that was not a very sight.
So because of that experience, do you think you would be able to set it aside and be fair and impartial in this trial?
Well, every case is different, so yeah, I'm sure I can.
Okay,
All right, that's time.
thank you, Judge.
Thank you. All right, defense, you may proceed.
Good morning, everybody. Come on, you can do better. Come on, good morning.
Good
morning. Okay, there we go. I know it's been a long day. Been a while since breakfast. As you heard, my name is Roberto Ambrosino. Most of my friends call me Rob. I see after this, you can call me Rob. I am a criminal defense attorney. So I hope you guys don't have anything against criminal defense attorneys in general. Yeah, no. Well, if not, then let's not hold it against Carlos. This is Carlos Perez. He's the one under trial here. He's the one that's sitting here in judgment of you. Gonna be in judgment of 12 of them. So that's not an easy thing. Carlos has spent his whole life here. He grew up here. He has 3 children. He worked.
All right, that'll be sustained.
As I mentioned, Carlos is the one under trial here. Moving on a little bit here. Essentially, Carlos gets to have an attorney, right? The 6th Amendment says that everyone gets to have a lawyer. So I'm his lawyer here today. As the judge mentioned, Carlos is accused of having fraudulent identifying information. Has anyone ever had a situation with that? Has anyone either had their identity stolen or anything along those lines? Okay, we have quite a few. Juror number 15.
Yeah,
Can you explain your situation?
I'm sorry. They stole my purse out of my car and
Who's that?
this couple, I worked at a convenience store at one time and they got my purse. My door was locked. I don't know how they got it, but I'm sure they opened it. And anyway, they took it and they got my credit cards and they bought TVs and stuff at Walmart and they bought their gas and all that. And yeah, it was pretty sad.
In spite of that, do you feel like you could be impartial?
Yeah, I mean, like I said earlier, every case is different.
Right, that's very fair. And that's what I'm asking you to do for today. Someone else raise their hand. 30. I'm sorry, I don't think she mentioned this, but like just to be perfectly honest, the people that are closer to the front are more likely to be on the jury, so we might focus more on them. It's not like we don't like you. We like you. It's part of the deal. I'm sorry. Go ahead, juror 23.
I had got a bank call. They said they were the bank and I gave them my information. My bank account started looking low and I hung up the call. I called my real bank and they said, we didn't call you. So they were taking money while saying they were the bank, but they weren't the bank.
Okay, in spite of that, do you feel like you could be impartial?
Okay.
You can try, but you're not sure.
Yeah.
Okay, fair enough. That's all we're asking. And you could be a good juror for some cases, but maybe not for this, right? Moving on. You heard a lot about police officers. Do police officers ever make mistakes? Right? Are they perfect? Are they infallible?
No.
Do police officers, just by virtue of wearing their police officer uniform, do they get any extra credibility on the witness stand than anybody else? Is there anybody that thinks that they do? They see a police officer as they testify and says, or thinks to themselves, well, they have to be telling the truth because they're a police officer. Does anybody think that?
No.
Very well. You heard the judge say that you don't decide Carlos's fate today, whether he's guilty or not guilty, until you hear all the evidence, right? So this is a trick question. I'm gonna take a vote. As he stands right now, is Carlos guilty or not guilty? Who says guilty? Who says guilty? Nobody, right? You've heard no evidence, right? So you've heard nothing. So you don't make the decision until you're at the very, very, very end. So you've heard all the evidence. So you don't make your decision in the beginning. You don't make your decision now. You don't make your decision until you've heard everything. Does anyone have a problem with that? Is anyone like, no, I can't stand a judgment that way. I'm gonna make a decision. I'm gonna prejudge. Is everybody okay with that? Fair enough. Do we need to, as the defense, put on any evidence? Do we have an obligation to do that? Who has the obligation? Who has the burden of proof in this case? They do, right? So they have to put on evidence. So if they call their witnesses and then it comes to us and we decide to call no witnesses, can you guys, I guess, realize, would you be able to hold that against Carlos? Would you hold that against Carlos if we call no? Call no witnesses. What if you don't hear from Carlos? Carlos has a Fifth Amendment right not to testify. The judge talked about some reasons why he might not want to testify or why someone else in the situation might not want to testify. Is there anyone that's here and just thinks to themselves, like, I have to hear from him? And if I don't hear from him, then I'm just going to be more likely to find him guilty or I can't be fair and impartial. Does anybody think that? Fair enough. You guys are agreeing with me a lot. I want to ask juror number 4, Miss Valdez. How you doing?
Good.
So you wrote in your questionnaire that you had served on a criminal jury, and you raised your hand. You had served in a criminal jury.
Correct.
Correct. What kind of case was that?
Rape.
Oh wow. Okay. Sorry to hear that. How long ago was that?
Oh, it's been a while.
Like over 20 years?
Yeah.
Okay. If you don't mind me asking, what was the verdict tonight?
He was not guilty.
He was found not guilty. Okay, thank you. And if any of the questions I ask you make you feel uncomfortable, just tell me. I don't prefer the answer. They can call you up after. Thank you. I appreciate you. Moving on. Does Carlos have to be like a great guy for you to find him not guilty? What if him sitting here, the way he looks, is there something you don't like about him? Does that mean he's guilty? No. What if during the course of the evidence, there's some things that you hear that you don't like? Does that automatically make him guilty? No. Does Carlos have to be innocent to be not guilty?
No.
No. No, he doesn't, right? So at the end, you're not going to decide if he's innocent or guilty. You're going to decide if he's guilty or not guilty. There's a difference, right? She explained to you and did a good job and explained what beyond a reasonable doubt is, right? And so if you find that they've met their burden, the state has met their burden beyond a reasonable doubt, then you would find him guilty. But if you don't, you find him not guilty. So does that mean he has to be innocent of everything he's ever done? No. Does that mean he has to be completely innocent and a perfect person?
No.
It just means you find him guilty or not guilty. Right? Does anyone have a problem with that? Is anyone confused by that or anything? No. You guys are quiet. Going back to the burdens of proof, the judge explained it to you, and she did a good job. But I just want to kind of explain it to you a little bit more visually. So the state has the burden of proof today, right? We don't have to put on any witnesses, we just call anybody put on any evidence. And so they have the highest burden of proof in the law. What that means is beyond a reasonable doubt. So basically, that's the highest burden of proof that we have. So let's assume that these were all the burdens of proof that we could have in the law, and this was a lie that depicted that vision, right? So if we're here at the bottom, this is 0. Let's say that table is 100. Right? So basically, if you just stepped up here, this is reasonable suspicion, which is essentially the evidence that would take to pull you up, right? So just a little bit, right? And then we're moving up a little bit. This is probable cause. So essentially what this is the burden of proof would have to be met in order to get a search warrant. Right, so a little bit more than reasonable suspicion, but not that much, right? And then we move to about, say, the middle, right? So this is preponderance of the evidence. So this is what's used in most civil cases. So if you were to sue somebody for negligence, because they wrecked their car and injured you, it's basically 50% plus one. So that's the burden of proof that you carry in a civil case to prove that, right? Everyone understand? Anyone have any questions? Okay. So we have two more. So we're at 50% plus one, right? And then we go up to here, and this is clear and convincing evidence. So we're like somewhere between preponderance of the evidence and up to the reasonable doubt point, right? To the end. And essentially what this is most often used for is in CPS cases. So to terminate your rights, your parental rights on a permanent basis, this is the amount of evidence that they need. So it's clear and convincing evidence. So significant, right? It's more than preponderance. But even after that, we're still not up to reasonable doubt. That's all the way up here. It's a very high standard. It's the highest standard in the law. And you have to hold them to that because that's your job. That's what you agree to do. That's what you say that you're going to do by being here, right? Sometimes I hear jurors say that, or not really jurors as much, but just people in the community say that we have too many rights in this country, that the criminal trial system takes too long, and then the appeals take too long, and people are just, it should just be much quicker, and we shouldn't give anyone, I guess, the amount of rights that they have in this country, and they have too many. Does anyone think that? Is anyone in agreement with that? No? Okay, that's good. You guys are fair. Has anyone been given a false check before? Going back to the one specific, has anyone received one?
A bad check?
Yeah, has anyone given you a bad check? You have 56. So just, I guess you said you're a comedian, right? So did someone give you a bad check after a performance? Magician of sorts.
I wrote a check on a couple of occasions.
Okay. Okay. And I mean, you didn't know though at the time that you had received the check, right?
No.
Someone could give you a bad check and you wouldn't know necessarily, right? Until you went to cash.
Correct.
Right. Right. Somebody else had a situation? 32.
Yeah, just receive checks for work and, you know, it's clear.
They were clear.
They did not clear.
Oh, they didn't. Okay, I'm sorry. I had a hard time. It's just a kind of pattern. Okay. But again, you didn't know until you actually went to the bank and cashed. Right.
Correct.
So there was no way for you to know until someone went to try to resolve it. Right. Okay. In spite of that, could you be a fair juror here to that thing?
Yes.
You feel like you could? Feel like you could be fair and impartial?
Yes.
What about you, sir? Do you feel like you could be fair and impartial?
I believe so.
55?
I work in a customer service where I do see bad checks given to me.
Okay, probably more than one, right? Okay, but in spite of that, you feel like you could be impartial?
I'm
Try
sorry,
your best.
I can't hear, and I know the court reporter can't. So if you can keep your voice up.
You try your best, but can you? So we'll take that as yes?
Yes.
Okay, maybe we'll talk to you later. Going back to police officers. So there's two types of witnesses in the trial. There's fact witnesses and expert witnesses, right? So unless they have some type of certification, what type of witness is a police officer? Fact witness, right? So basically the job of a fact witness is just to come in and testify about what they've observed, right? An expert witness is someone who might give their opinion about something based on their expertise or training that they have. But most police officers, unless they have some type of special type of training, are fact witnesses. So they're just a fact witness, just like anybody else, even though they're wearing that uniform, right? Does anybody have any questions for me? Does everybody in here feel like they could be fair and impartial? Yes. Would everybody give Carlos a fair shake today and not make a decision until they hear all of it?
Yes.
Thank you.
All right, ladies and gentlemen, I'm going to have you all wait outside. And then we will call you back in and you will know which persons will be on the jury. Please leave behind the white cards and take all your personal items with you. And wait 1 second. Look, 1 second. Excuse me. Look to your left. Look to your right. You're responsible for that person being in line when we call you all back in. All right, everyone, step outside.